We've already talked about how public interest lawyering differs from many other forms of litigation, and one crucial issue to consider is the question of the client. Should public interest lawyers only take on individual clients whose cases further the broader strategic aim? How do we even find clients, or do they find us? It's tempting as public interest lawyers to focus only on the broader systemic strategic issue. For example, the battle to secure textbooks or school furniture for all students across South Africa. But the individual client must not be forgotten. Their interests and rights obviously matter very much. And their presence in a case can add a human face, and that can be very effective with courts. There are also the risks that clients may face when stepping forward to get involved in litigation, and those risks must be considered. Ultimately, public interest lawyers need to try to strike a balance between the interests of their individual clients and the broader interests of all similarly affected students. In this module, we begin to talk to lawyers about how they've adopted different approaches to try to strike this balance, and in particular to empower their clients and make sure that their voices are heard in the litigation.
You always want to ensure that you've got the sympathy of the judge, and to do so means that you want to find the client with the direst of circumstances. I recall once we were approached by learners within a very rural part of one of the provinces in South Africa, where they had written saying that the principal hadn't been to the school for weeks on end, that the infrastructure was completely dilapidated, that the textbooks were dated 1980 odd, and the circumstances were so appalling that we thought that they would make not only the ideal client but also the face of the court case. So whilst also representing the institutional client on an equal education side, we combined the court case and ensured that the learners were at the fore, that they were the first applicants. The difficulty though with this is that there was also a backlash in the sense that you're dealing with children, and often the schooling space is a space within which children can be victimized, and they were victimized for speaking out and coming forward.
There are cases brought in by individuals, there are cases brought in by organizations, or sometimes by a combination. You have petitioners who are both individuals and NGOs or organizations. We often find that in RT, right to education related petitions, having learners or students or children being petitioners is extremely useful. It gives it gives to the court the real story and the face of the student, and that usually makes a great impact. Often the combination of having an individual petitioner and NGOs is also really useful, because an individual petitioner or a learner, or even if it's an individual activist, may not have the resources or the wherewithal to actually follow up in the matter, get the order implemented, or really do more outreach work, which a litigation needs, and an organization can do that. So to ensure that the case or litigation is more effective, we often use NGOs, and even in the kinds of organizations, the ideal client would really be an organization that would have some resources to take the case out in the media, give it some coverage, do some monitoring, and work with government agencies to ensure that the orders are implemented.
You must find the right client for the right case, for the right relief. And those are the sort of three ingredients that tend to work in public interest litigation. You must balance them out. But clients are not perfect. And so you have to work with a particular set of clients that you have. And sometimes what you perceive at the beginning of the case to to be a particular advantage of a client might turn out not to be that of an advantage, and then you have to resort to the issue and the remedy in order to cover the defects in the characteristics of the client.
With the social justice movement client, they are absolutely central to the court case. They want to be involved in every detail in a meaningful manner. And it's important as activist lawyers that we remain conscious of this. I think sometimes we are so passionate and sort of over-eager that we want to run ahead because we know the law and we know what's needed, but it's important that we adopt a humble position. Your social justice movement also wants to be empowered and own the case. It's their court case, and so for me, conceptually trying to frame this in a way that I could always be conscious of it moving forward, I'd consider it in a way that as the lawyer of this huge public interest case, I'm the godparent. I'm there to ensure that the case is steered in the right direction, but the social movement that I represent, they are the parents ultimately, and it's them who have the ultimate say in the way in which that case should be raised.
The specific role of the client is really to bring out his or her actual experience to the case, and that is really important in building the story when we want to go to court. The client needs to take ownership of the case and not just lend her name to it. She needs to take ownership of the case because the case would need constant inputs, constant monitoring, and therefore, unless the client is able to do that, the client's role would not be properly fulfilled. The client, if it's an NGO or even an activist, can also add to the strategy of the case because to develop the strategy, because if we look at long-term measures, what kind of remedies we want to frame, the organization, if it is working very closely on the ground and has been active in the field of education, can help lawyers in strategizing what kind of remedies can be sought for, what kind of remedies can be monitored or implemented, and build a strategy in that way.
In cases where we have individual clients who represent a systemic issue, there is always the risk that there may be settlement or a resolution that is actually in the best interest of the client. In the case of Masafa, which is the fee exemption case, we included requests for relief that has a structural impact. And Masafa herself was dedicated to that final relief. And so in that instance, we see the litigation actually having been concluded. We had a High Court judgment, which was really about addressing the systemic issue. That is now on appeal, will go to the Supreme Court of Appeal. But there are cases where the individual client's interests may ultimately be best served through a settlement or through some sort of negotiated resolution. And in those instances, for the Equal Education Law Center, the paramount principle is the best interest of the child. And if the resolution will secure the best interest of the individual child in that case, then we may in fact have to resolve the case in that way.
This is tricky, and there needs to be a good balance in ensuring that the goals of an individual client or an individual organization and goals of the larger movement or the community are both kept in mind. Sometimes if the petitioners are individual learners or students, they might want their relief to be granted, which could be, for example, in the Indian context, admissions to private schools. On the other hand, the larger goal of the movement could be to ensure that private schools have norms and standards implemented and adequate infrastructure and all other requirements of the law. How do you address both of those? I think the way to address both these interests is to actually strategize in how remedies are framed, and you make sure that prayers are drafted in a way that both individual remedies and the larger structural remedies are both in the petition, and that is one way of ensuring that there's no conflict. That such a conflict does not arise, because in most cases, even though there may be separate interests of individual clients and the larger community, they are not necessarily in conflict. So while individual learners may seek admissions, the larger remedies of, for example, seeking norms and standards implemented are not really at conflict with each other. We also try to ensure that when you're strategizing the case, these, if there are potential conflicts, these are discussed, and the petition is framed in such a way that there are no potential conflicts. And if during the petition it does, a situation does arise that certain reliefs are being granted by the court, then we need to keep we do plan how we would address such a situation so that the larger remedy or the larger prayer is not lost sight of.
In the work we do, you often anticipate that government will settle in order to make an issue go away, and we often see that particularly within education litigation. And what we often do is we identify individual clients who personify the real life story of the injustice we're seeking to remedy, and then combine that with an institutional client like equal education. We then draft our papers in a way that would ensure if the individual clients fall by the wayside through a settlement process, that the case can nonetheless push forward.